a regulatory explainer on the role of administrative agencies in state government. California's administrative agencies play a key role in state government and in the development of public policy in our state. That's because there are over 200 state agencies, departments, boards, commissions, and bureaus which have the authority to implement, interpret, and enforce state laws and regulations. These executive branch entities enjoy quasi legislative, that is, the authority to adopt regulations that have the force and effect of laws, similar to the legislative branch of government. This is often called their rulemaking authority. They also enjoy quasi judicial, that is, the authority to interpret laws, similar to a court. Now, these state entities also formulate and influence state policies and legislation by administering the laws adopted by the legislature, as well as executive orders promulgated by the governor. As a result, state administrative agencies are often important players in public policy development in the state. For example, by influencing pending legislation that impacts their jurisdiction, such as air quality by the California Air Resources Board or CARB, interest groups, the legislature, and the governor are impacted by their views on legislation. They also interpret statutes, they enforce the laws, and they adopt regulations to implement the statutes enacted by the legislature. Because they're also a part of the executive branch of government, these entities are generally responsible to the governor. But they also play an important role in advising the governor and his or her staff on pending legislation, the state budget, and related public policy issues. As such, those engaged in developing public policy must engage with these administrative agencies as well. And as a result of their input to the governor, legislators and interest groups must consider the views of these agencies and departments when considering legislation as well as the pros and cons of particular bills or substantive issues. In fact, the recommendations of state administrative agencies, just like their federal counterparts, carry great weight with the governor and his or her staff when making their decisions. The regulated community must also pay close attention to the work of these state agencies, departments, boards, and commissions. They all have general or specific rulemaking authority, which means they can add, amend, or repeal regulations that impact those regulated by them. For example, nurses by the state nursing board, or agricultural companies that spray their crops by the Department of Pesticide Regulation. In addition, by having enforcement power, these state agencies can enforce the statutes and regulations governing the conduct of those that they regulate. This means that these state entities can investigate a company, cite or fine them for a violation, in some instances, even suspend their license to conduct business in our state. This enforcement power is very important and means that these state entities are influential naturally with the regulated community that they oversee. So, whether conducting investigations, enforcing, or interpreting the laws, state administrative agencies are a crucial player in state government, and they wield enormous power with a myriad of different entities in and out of California state government.